And that's how this conference came into being. Now, the vision of the e-courts project is to provide affordable, accessible, cost-effective, environmentally sustainable, transparent, and an accountable justice delivery system. Each of these phrases is not just a phrase of art or a label, but it signifies the core of our mission of reaching out to citizens, of replacing what was the earlier colonial model of the administration of justice, under which citizens had to reach out to courts. We seek to now replace it with a model where we reach out to citizens and allow us to provide every kind of resource and service to our citizens. Now, if you look at the outlay for phase 3 of the e-courts project, which is going to be between 2023 to 2027, the total outlay which we have envisaged is 7,210 crores. Of it, the outlay for 2023-24 is 2,024 crores, or nearly 2,025. 2024-25, 2,109.6. 2025-26, 1,523 crores. And 2026-27, 1,552 crores. Compare it with the outlays in phase 1 and phase 2. The outlay for phase 1 and phase 2 combined was a fraction of the outlay for phase 3. And perhaps phase 1 and phase 2 was no more than the outlay for the first year of the e-courts project in phase 3. So we can now look at the enormity of the funds which the Government of India is providing to us. I must share with all of you, all our sisters and brothers, particularly who are here from the High Courts, that when we pitched for this budget, the Union Government responded, the Ministry of Finance, and we were ably assisted by the Department of Justice, responded by not even making a cut of a single rupee in the funds which we envisaged. Because the importance of this was that we presented it properly. We were able to explain to the financial arms of the government on what the benefits would be in terms of this outlay which we propose for the Indian judiciary. Initially, during our meetings with the Ministry of Finance last year, the view was expressed that let this be a centrally sponsored scheme in which the center and the states would bear their own shares. But our experience in the past has not been uniform across the country. During the course of the 14th Finance Commission, there was a devolution, the increased devolution from 32 to 42%. But the experience which was gained in the course of the 14th Finance Commission, and this was noted in the report of the 15th Finance Commission, is that despite the increased devolution, the states were not willing to share funds with their judiciaries. And there was no way that the High Courts to tap these funds. So both the Department of Justice and the E-Committee of the Supreme Court impressed upon the Ministry of Finance that if this project is truly to achieve its mission, and particularly having regard to the fact that phase 1 and phase 2 were 100% funded by the Union Government, the same principle should be followed for phase 3. And that is how it is going to be. 100% is going to be provided by the Union Government. During the course of a meeting which I held with the Department of Justice just a few days ago, and I'm sure both Mr. Rahate as well as Mr. Prasun Pandey and Mr. Ashok Kumar would be sharing these details with you, there are two options which the Department of Justice and the Expenditure Finance Committee has created. The first option, which is Model 1, is the default option. The default option envisages that the entirety of the funds would of course be provided by the Union Government and channelized through the E-Committee, but at the same time, this would cover the specifications which we lay down for the entirety of the country. The second, which is Model 2, which is very innovative and which is something which I'm sure all of the judges here who are chairpersons of the ICT committee and the Chief Justices would like to devote themselves, after it is explained in greater detail by the representatives of the Department of Justice. Model 2 envisages something which I have been hearing from our colleagues across India. Model 2 envisages that if a state wants to go in for higher specifications, a state, for instance, feels that I don't want to be constricted by the minimum standards or the threshold standards which have been laid down as part of the e-courts project, but my budgetary outlays are going to be higher and my state government is willing to provide that. Chief Justice Muralidhar has always mentioned to me, for instance, that the state of Orissa has been extremely forthcoming on the needs of the Orissa judiciary in terms of ICT initiatives. The state of Kerala has also been at the forefront. I know, as a matter of fact, that the state of Madhya Pradesh has been extremely hospitable to the demands of the judiciary. Several other states have been. Other states which I'll not name are woefully behind the tangent. So if there are states and if there are high courts which are able to get higher commitment of funds, then Model 2 envisages that you can increase your specifications, you can set higher targets. In fact, I have constituted an advisory committee consisting of Justice Rajiv Shakdar, Justice Suraj Govindraj, Justice Raja Vijayaraghavan, and Justice Anup Chitkara. Part of it was selfish, because as Chief Justice of India, I can devote only so much time now for the E-Committee, but I don't want to cede control over this mission of mine. But the committee has been constantly telling me that their high courts have done much better work than what has been envisaged by the E-Committee. At a certain level, we require national uniformity. At the same time, national uniformity does not account for the fact that there are high courts which are far ahead of the curve. So Model 2 will really, in that sense, take into account these concerns of the high courts, that let the e-courts project not be a constraining influence on our activities, but a source for providing a minimum standard for the entirety of the nation, a uniformity, which, while providing for the basic needs of states, especially the cash-strapped high courts and their district judiciaries, do not operate as a sort of a constraining influence. Now, what are the major activities of Phase 3? The first, and that I want to emphasize, is the creation of digital infrastructure. Digitization is envisaged, the budget is close to 2,038 crores. Technological advancements, cloud infrastructure, cloud storage has a budget of 1,205 crores. Digital preservation, access to critical services that I'm going to be speaking of very shortly, and change management. Among other activities, you have software development, which is about 243 crores. Now, there are 24 major components in Phase 3 of the e-courts project. Out of these 24 components, the Department of Justice and the E-Committee have tentatively, I say tentatively because it's subject to discussion with all our high courts, identified 13 components where there may be a need for centralization. And why centralization? The reason for centralization, for instance, is that in the area of digitization and scanning, the Expenditure Finance Committee, while releasing the 7,200 crores to us, has made certain binding recommendations. Among those binding recommendations is that scanning and digitization must be subject to open price market discovery. We envisage that about 3,108 crore documents would be digitized at a certain per page estimation. The Expenditure Finance Committee has highlighted that perhaps if you were to scale up and subject your digitization estimates to open market discovery mechanisms, the price per page will radically reduce. Now, the need, therefore, for this is that we need to have a centralized national agency. I'm conscious of the fact that several high courts have already begun the process of digitization. So when we have a uniform national agency, some of the best market players in India who are involved in the process of digitization across India, we'll have to take into account the work of digitization which has already been done, whether it be Orissa or Delhi or Karnataka or Kerala. The idea is not to obliterate the work of digitization, but take into now account the work which has been done and then look to the future. So apart from the fact that you have digitization and scanning, which has to be subject to open market discovery of pricing, it is important to look at certain other areas as well. The digital infrastructure which we intend to create, and which is my next slide, is firstly paperless courts. Second, virtual courts. Delhi has been leading from the front in the creation of virtual courts, particularly in the area of traffic challans, of which we heard a short while ago. The footprint of the paperless courts has to be expanded. Live streaming, which is dependent on a robust cloud infrastructure. Today, most high courts are doing live streaming on YouTube, with the attendant problems which we have been hearing in the earlier part of this presentation this morning by Chief Justice Muralidhar and by Justice Rajesh Bindal. You have these little clips about a judge in the Patna High Court asking an IAS officer as to why he was not appropriately dressed in a suit as opposed to being dressed in only a shirt and a trouser. Or somebody in the Gujarat High Court saying something about, why a lawyer is not ready with her cases. So a lot of funny stuff is going on the YouTube, which we need to control. Because this is serious stuff. What happens in the court is extremely serious stuff. Live streaming that we are doing has a flip side. We as judges need to be trained ourselves because we are now working in the age of social media. Every word which we say in the court is up on the public realm, which we realize when we are hearing the Constitution bench arguments. Very often citizens don't realize that what you say in the course of a hearing of a case is to open up a dialogue. It doesn't reflect what you're going to ultimately decide necessarily in every case. In some cases it may, in some cases it may not. But people don't understand this at large. So live streaming, our interface with social media, places new demands on us as judges. But therefore we need to create a robust cloud infrastructure for live streaming. And cloud infrastructure perhaps is one way where we have to have a national model, a centralized national cloud infrastructure, not in terms just of price discovery, but of upscaling our activities. We'll also have to have additional hardware for new courts, renewable energy. The next important area which I want to emphasize is the technological advancements which the Phase 3 document envisages. And this will refer to software development, the use of artificial intelligence, blockchain, and digital accessibility. We are conscious of the fact that artificial intelligence has the flip side as well. For instance, we would be very difficult and diffident in allowing artificial intelligence to tell us what sentence to hand down following a conviction in a criminal case. Many courts across the world have experimented with it. I don't think that we as judges would ever want to cede our discretion, which we exercise on sound judicial lines, in terms of sentencing policy. But at the same time, artificial intelligence is replete with possibilities. It's now par for the course in a hearing in the Supreme Court to have a record of 10,000 pages, or 15,000 pages. Appeals which come to us from the specialized tribunals, like the APTEL, the Electricity Tribunal, or the Competition Commission, have huge records. How do you expect a judge to digest evidence in a statutory appeal in a record involving 15,000 pages? Artificial intelligence can prepare the entire record for you. Or, for instance, we have been using artificial intelligence for transcription of the proceedings in the Constitution bench of the Supreme Court. Simultaneously with the arguments, we have a screen in the court in which the entire oral argument is transcripted. At the end of the day, the transcript is provided to all the lawyers to clean up any errors which may have taken place. There were very funny errors which sometimes takes place. One of the arguments made by the lawyer for the petitioner was confused with the lawyer for the government of India. It was obviously cleaned up by the end of the day when the lawyers notice it, and then it is put out on the website for public consumption. But transcription is another AI-assisted activity which we are in the process of implementing. As you know, we are now launched into translation of judgments of the Supreme Court. There are about 34,000 judgments, core 34,000 judgments of the Supreme Court since independence. All of these judgments were digitized by providing an ESCR free of charge. And the idea behind this initiative, which I was pursuing since 2016, but I realized that some things can only be achieved when you become Chief Justice, because perhaps people listen to you better. I don't know what the secret to that is. Justice Muralidhar is also an example of that. But what happened is that I thought that we must put out our judgments which should be available free of charge. The private software developers provide great service. But why should it be that a citizen has to pay the kind of charges which are levied by private software developers when our law colleges are not resourced? Our lawyers in the talukas or the district courts are not resourced to pay for the software. In about 2 months after I took charge, we have all the 34,000 judgments now in the form of an ESCR. But we are not stopping at that. What better way, I thought, to provide access to justice to our common citizens than providing our judgments in a language which our citizens understand? And therefore, we are now in the process of using artificial intelligence. IIT Madras, which I believe is going to be making a presentation here, is at the forefront of that activity. But we've also used our retired district judges across high courts to verify the correctness of the translation which is being made before these translated judgments are put out on the internet. The next aspect which I would like to stress on is the need for e-Seva Kendras. Now, e-Seva Kendras are a core part of our mission in phase 3. E-Seva Kendras are important because we envisage that we will set up about 4,400 e-Seva Kendras across India at a budgeted outlay of about 394 crores. Now, an area which I want to throw up for discussion and for reflection by all the colleagues today from all high courts and the CPCs, while setting up e-Seva Kendras, can we not do something and replicate a pattern similar to, say, the passport centers? This is something which was raised just the other day with me by the team from the Department of Justice. We have passport centers across India which are run by a pan-India agency. There are two critical requirements of e-Seva Kendras. First, a certain degree of uniformity. I have all these inaugurals which I'm invited for across India, and I'm always wary of the fact, is this an inaugural only to have the Chief Justice of India to come and grace that particular event? It's important for us to have uniformity in the kind of facilities which we will be providing to e-Seva Kendras. Now, if you have to have uniformity, you can scale it up. You obviously cannot have the same e-Seva Kendra for a court establishment which has, say, 5 courts, with a court establishment which has 150 courts in UP. But you must therefore have a uniformity of facilities which we will provide in e-Seva Kendras and then scale it up depending upon the footfalls, depending upon the number of cases, depending upon the number of judges, depending upon the number of lawyers who have access to that court on a daily basis. Cloud by default is, as the next slide indicates, one of the key missions of phase 3. In other words, all applications will have to be migrated on cloud. We must provide for a redundant and robust connectivity. We have just heard a short while ago of the serious problems of connectivity which we have across India. But the answer to that will be by having maybe one or a few agencies which will really provide for redundant connectivity. Disaster recovery, cybersecurity. On cybersecurity, I have constituted a committee. Most of the committees which I constituted during the pandemic, for instance, I constituted a committee on live streaming rules. I constituted a committee on preparing e-filing rules. We constituted a committee on an SOP for digitization. The committee on SOP for digitization was obviated by one basic aspect, namely, what happens if the technology which we adopt today becomes obsolescent? at least I grew up, many of the young judges here may not have grown up in the same age in which I grew up, but I grew up in an area when you had these records, the long playing and the short playing records. They gave way to your cassettes with the spools, then the smaller cassettes, then the CDs. I still have a CD player, but it is absolutely redundant because nobody plays CDs anymore. What happens if the same thing happens to our digitized record? How do we ensure that this huge outlay of public funds does not become redundant? And therefore, we constituted a committee on SOP, for an SOP on digitization, of which Mr. Katre from CDAC, who's going to speak to you, was a very integral part. All these committees have done their work, but there's one committee which is still doing its work, and that's the committee which is chaired by Justice Rajiv Shakdar. Many of these others were also chaired by him. One of the committees is the Committee on Cybersecurity and Data Security and Privacy. And naturally, that committee is taking time because that is the most difficult part of our work. How do we ensure data security? And how do we ensure data privacy? We have opened up our APIs, our application programming interfaces, to all government departments as step one. Recently, we shared our APIs with a governmental agency. Before we realized that government agency had put up the APIs across India for public consumption, we had to scramble and request them to pull back the APIs from the public domain because we said, look, we can't put these APIs for public consumption across India for the reason that this deals with very sensitive data of individuals, marital problems, child sexual abuse, gender violence, commercial confidences. So we are in the process of evolving a national model for data security and privacy. And the moment that is done, I think we would have achieved a very major step. On digitization, I want to highlight a few key areas. First, digitization of court records. I've already spoken about the digitization SOP. The next, which is a very important aspect of phase 3, which is establishing a judicial data preservation software, which we would need to establish for data security. The next, catering born digital data, because now what will happen is in phase 3, a lot of our data would be born digital. We would not be scanning data which was either in the paper form or scanning something which was e-filed, but it will be born digital data. So how do we cater to the born digital data? And then finally, moving towards and enabling a paperless court. In the next slide, I've already referred to the e-Seva Kendras. We also need to have a robust e-filing platform. We are now on the anvil of e-filing 4.0. Video conferencing, which I've already spoken of. There's an area which I would like to refer to on video conferencing. The Parliamentary Standing Committee on the Department of Justice visited the Supreme Court on 2 occasions. It was in fact not a part of conventional protocol for the Supreme Court to engage with the Parliamentary Standing Committee, but I got a request from Mr. Sushil Modi, who chairs the Parliamentary Standing Committee, and he very graciously asked me as to whether the Supreme Court E-Committee would be willing to engage with the Parliamentary Standing Committee. I consulted Chief Justice Ramana, who was my Chief Justice, and he said, brother, if you have no problem, I have no difficulty. And I engaged with a host of members of Parliament across political lines. And I can share with you that there was just a sense of awe at the work which has been done by the Indian judiciary, particularly in the ICT area through the pandemic. And part of the reason why we were able to sustain the budget which we had planned is because of the robust support which we got from the Parliamentary Standing Committee. Thereafter, the same Parliamentary Standing Committee came to engage with the Supreme Court in its activities with NALSA, which is chaired by Justice Sanjay Kishan Kaul. Now, one very important part which the Parliamentary Standing Committee made before us was this. They said that when we visited various high courts, we found that so much of the technology infrastructure which has been set up is obsolete in the sense it's not being used by the high courts at all. Screens, the computers are just put away in a portion of the court as a sort of a reminder that we used technology at some point of time in the past. And the Parliamentary Committee had a very cogent point. all these public funds which we are utilizing, does it make sense if so many high courts are just discarding the infrastructure which we have set up? Now, I explained to the Parliamentary Committee that what you see at the front end of the High Court is not all the technology that we have. The whole High Court infrastructure is running on technology. So maybe some High Courts have now disbanded the video conferencing equipment, but that doesn't take away from the fact that the infrastructure is still in place. But I've written to all Chief Justices of the High Courts, informing about these concerns and requesting them not to disband the infrastructure which we created during the pandemic. Now, most Chief Justices have written to me saying that we have so many video conferencing equipments in place in the court. The question is not about the fact that we have these video conferencing facilities in the courts. The question is, are we using them? I get a lot of PIs as Chief Justice of India in the Supreme Court of India. Lawyers across India, whether it's from the Punjab and Haryana High Court or the Bombay High Court or some other High Court, telling us that, well, hybrid hearings have been stopped by the High Courts. Our High Courts have just shut down hybrid hearings. I would like to appeal to our Chief Justices and to all the chairpersons of the ICT committees, please don't disband the infrastructure which we created during the pandemic. COVID-19 provided us a justification. It was an imperative. But technology is not something which was confined only to the COVID-19 pandemic. We must look beyond the COVID-19 pandemic. I'm sure that the High Court Chief Justices and all of you who will go back home to your respective states will take this up further. And finally, change management, which requires capacity building, process engineering. Process engineering is something that the High Courts have still not looked at. When I was a judge of the Bombay High Court, we began a process engineering initiative for reworking our rules of court so as to re-engineer our rules of court bearing in mind the demands of technology. I believe 10 years after I left the Bombay High Court, process engineering rules have yet to be formulated. And I'm sure, I dare say, the same thing is all over the country. So process engineering cannot just be one blip on the horizon of phase 3 of the e-courts project. All of you will need to engage with your colleagues who are in the Rules Committee and ensure that we take this up very seriously and bring about process engineering. So many of our civil manuals, our criminal manuals, are completely geared to a different era when you had to actually serve summons on horseback or on camel. They're not geared for the technology that we are employing today. So this is something which is very key for all of you to really apply your minds to. Training of all stakeholders. The Supreme Court of India, for instance, is now ready with e-filing. Our e-filing module is completely ready. We have engaged with the bar, we have engaged with the clerks of lawyers on multiple occasions, and we are now doing the final stage. It has undergone the security audits, and we are now doing the final stage. We called it awareness. We have requested teams of lawyers, including the Bar Association, the lawyers themselves, the Supreme Court Advocates on Record Association, to come in groups, and these groups are being made aware of e-filing. We are also training the lawyers' clerks, the munshis, because for them, law courts are the source of livelihood. They can't be left behind in the march of technology. So what we are doing in the Supreme Court now is to train all stakeholders. Our next step is to identify about 10 lawyers who will now be doing all their e-filing in the electronic mode, all their filing in the electronic mode. So the idea is now to have mascots, the representative members of the bar, who will do all the filing that they are going to do in the e-filing mode before we roll it out in the near future as a mandatory form of filing. But here again, I would like to highlight just a few issues. I had a case the other day from the National Company Law Appellate Tribunal, which I must share with you. When I was editing my judgment last night, I thought I must share this example with you. The NCLAT has rules which require that all filing must be by presenting the appeal at the filing counter of the NCLAT. Now, this is true about so many high courts as well, therefore I'm sharing this particular example. The issue was, when does limitation stop to run before the NCLAT? When a matter is e-filed, does limitation stop running? Or does limitation stop running only when the physical file is filed? The NCLAT came out with an office order saying that besides e-filing, you must also file your appeals in the physical mode. Now, I do believe that there can be no greater disincentive to a lawyer or a litigant than to require them that apart from e-filing, you must also file an appeal in the physical mode. If you have to file an appeal in the physical mode, the lawyer will ask you one question: why then do I have to file it in the e-filing mode at all? You might as well scan what I'm filing and then present it before your judges in the soft form. So the first thing which high courts need to do, and we've done that in the Supreme Court as well, is that we have ensured that once e-filing is implemented, there should be no requirement of physical filing. Now, obviously, the reason why a particular tribunal said that you must also file physical copies is because the judges of the tribunal were not very comfortable with e-filing. But something which I have said in my judgment, which is that the answer to our unease as judges in handling electronic files is not to burden the litigant by requiring them to file physical files. The answer is simple: just retrain ourselves. During the course of the Constitution bench, which I've been heading for the last several months, I've ensured that all my colleagues, some of them on the verge of retirement, have gone completely in the electronic mode. And I can only tell you as a mark of my appreciation for a colleague who is almost on the threshold of 65, of the eagerness with which my colleagues have gone into the electronic mode. It's all about a change in mindsets. Technology is meant for dummies. The back end of technology is not meant for dummies, but the front end of technology is really meant for you and me, people who have a basic interest in technology and the ability to use it. That's all. So this is something which I do believe is crucial to our initiative. Why should we really impose burdens? The Supreme Court of India, for instance, had a rule that even when you e-file, the Supreme Court would collect printing charges because the e-files had to be printed by the registry. Now I ask myself the question, does the government of India really depend on a few lakhs of rupees that you generate at the end of the year and deposit in the central treasury on the printing charges we collect for printing of the e-files into physical files? But what a great burden on lawyers, on the litigant who has to pay for printing charges. So these are small initiatives. The reason why I thought I might get into some of these, which are boring issues, but only judges will realize them, and most of us have practiced at the bar, and we realize how difficult these issues are for lawyers and for litigants. These are really low-hanging fruit, which each of you need to grasp and to ensure that you deal with them so that we can then change for the better. Just a couple of other thoughts and then I'll be done with my presentation. One, that we are on the anvil as part of our next mission of integrating the ICJS, the Interoperable Criminal Justice System, and the CCTNS with the e-courts project, so that all the data in ICJS and CCTNS can also become a part of the e-courts and which can be lifted by us, whether it is in terms of the details about the FIR, the charge sheet, the framing of charges, the evidence which is recorded, and almost everything which leads up to the final judgment in appeal. Last couple of points. One of the things which we envisage in phase 3 now is to have a project management consultant. The reason for the project management consultant whom we have proposed to appoint at a national level is that a lot of work which we are going to do in the E-Committee together with the Department of Justice, such as selection of agencies for centralized implementation or for laying down the specifications, drawing up expressions of interest, the RFP or the request of proposals. We have a few very expert officers across the country. One of them is from Madhya Pradesh, Mr. Kazi, for those of you who have interacted with him, who are experts on drawing up